tussle between the state governments and the governors over the stalled bills, the Supreme Court has today given a crucial verdict. This was a bench headed by the Chief Justice of India, Mr. Govt, and answering the reference made by President of India, Droupadi Murmu, under Article 143 of the Constitution, the Supreme Court held that the Supreme Court cannot impose any timelines for discussions for the President and the Governor on granting assent to bills under Article 200 or 201 of the Constitution. Now remember, earlier the Supreme Court had clearly prescribed a clear timeline for the governors not to delay giving assent, either give assent or send it back to, in fact, the government, and then, of course, for the president as well, that you can't keep sitting on bills indefinitely. Now, at that point of time, it was seen as a missive to the governors. Now it is being seen as some sort of a victory for the center. Now, many are calling this also, this entire order as a balancing act being done by the Supreme Court. So the question is whether the earlier order was a judicial overreach, and what does this order imply when it comes to the federal, the governor and the state government's relationship is. We have seen allegations from the opposition that the governor's office are being made as if they are an extension of the ruling party. I want to very quickly just point out the big highlights, ladies and gentlemen, of the order which has been given by the Supreme Court's bench today. Now, the Supreme Court has, in fact, said that no fixed timelines for governors or the president for acting on the bills. The president, the Supreme Court, in fact, goes on to say, not bound to seek Supreme Court's advice under Article 143 every time a bill is reserved. The Supreme Court has also, one of the big takeaways is that the decision of the governor or the president at the bill stage is not, justifiable. And this is an important, observation that the Supreme Court has made. The Supreme Court has also said Article 142 can't be used to grant, substitute or override powers of the governor or the president. The Supreme Court has also, in fact, said courts cannot replace, compel or supplement as assent as far as the bills are concerned. Now, remember, this has been a very, very important, in fact, whether you call it a U-turn or a balancing act, which has been made by the Supreme Court, because earlier, and I want to very quickly tell you about that, the Supreme Court had earlier set the timeline for the governors. This was in April 2025, when the Supreme Court pulled up Tamil Nadu Governor, Mr. Ravi, for sitting on bills. In fact, the Supreme Court had at that point of time said that the governor cannot indefinitely delay bills. The Supreme Court also said that the bill must be returned to the Assembly within 3 months, and the bill sent again to the governor must be cleared in a month. The governors cannot create roadblocks or chokehold the legislatures. Now, I very quickly just want just to refresh your memory, viewers, just want to give you a sense very quickly. There have been these squabbles and problems which have been going on between opposition governments, especially, and the governor's office. Tamil Nadu has 10 bills which the governor at this moment is sitting on and has not cleared those bills. The governor in West Bengal has also withheld 11 bills which have been sent by the Assembly of West Bengal. In Telangana, which is also an opposition ruled state, 6 bills have been withheld by the governor there. I want to very quickly at this moment turn my focus and get in Mr. Vikas Singh, top lawyer, who is joining me at this moment. Mr. Singh, thank you so much, sir, for speaking to us. For the benefit of our viewers, how do you view this judgment of the Supreme Court? Is it some sort of a U-turn, shot in the arm as far as the president and the central government is concerned? Or do you see this as a balancing act, sir?
So firstly, it is not this opinion. This is basically an advisory opinion. So it only does not upturn the binding decision already rendered by this court. But I think it's a good balancing act that has been done by the court. Firstly, they say that judicial review is possible. They say that it is not that the governor can unreasonably hold onto the bill and court will remain a mute spectator. So they say on a case-to-case basis, court can intervene. But at the same time, they say there cannot be any sweeping direction that in every case, if a certain period is expires, the bill will be deemed to be assented. So that is something which they say is not correct. And I think they have done a good balancing act, because that would be disturbing the constitutional balance between the judiciary and the executive. And
Yes.
say that judiciary will have a role to play if there is a particular case where the governor unreasonably delays, but at the same time, to say that by and large, the discretion of the president or the governor in giving his assent
Okay.
is, sort of maintained also in this judgment.
Sir, may I ask you, because the court today in its observation relied heavily on as soon as possible when it comes to clearing of the bill, and said that prolonged inaction could in fact once again get the some sort of a judicial review or action by the judiciary. How will the court or anybody else quantify inaction for a foreseeable time? Is there a clear guideline to that?
So ultimately, the issue will be that you have to respect the executive as well. You just can't, but at the same time, the court also, I mean, they have not said so in so many words, the court expects the president and the governor to act reasonably. And if this kind of a holding on to bills only in opposition states is happening, then it can't be said to be acting reasonably. The three options that they've given to the governor, they say either he assents to the bill or he sends it back for reconsideration. Holding on indefinitely is not an option which they say is there with the governor. So it's actually trying to nudge the governors that look here, we also feel that you just can't hold on to these bills indefinitely. But at the same time, we are exercising judicial restraint in saying that no, if you just because you've held on to a bill for a long period of time,
Yes.
there would be a deemed assent. So that's the way the nudge is happening in my view of the constitutional authorities, that while they function in this capacity as a governor, they
Right.
have to also be mindful of their responsibility, because ultimately they don't have any power to reject the bill. They only have a power to
Okay.
send it back for reconsideration.
Mr. Singh, let me also ask you this, because a lot of people, when the earlier judgment was passed, were looking at that as a shot in arm, especially for the opposition, where the governors are sitting on various bills. Now, the people, those who criticize it, are celebrating, saying that it was a judicial overreach which has been corrected by the current order.
So two things. So there is no question of judicial overreach in the matter at all. And because, as I told you earlier, this is not going to upturn a judgment given inter partes. This is just an opinion given. But at the same time, it also is, reminding the constitutional functionaries, especially the governor and the president, that they have a certain responsibility to the parliament and to the state legislature, and that they should act, and the options available to them have also been spelled out. Now, if you say that this is a victory for them, I would not agree with that, because it's not a victory in that sense. It's a victory of the constitution or the constitutional scheme, because they have tried to maintain a balance by not commenting. They were anguished by the way some of the governors were holding on to these bills, but they said the answer doesn't lie in court directing the bills to be deemed to have assented. So that's the kind of balance that they have tried to strike in this judgment.
Sir, my final question to you at this moment, you said that it is not going to have any binding as far as the previous order is concerned. Going forward, if a state government feels that they have been unfairly targeted, what are the options that they have given the precedence which has been set now?
So if a state government feels that a particular bill has been unreasonably delayed and has not even been sent back for the reconsideration of the government, the state definitely will have a right to move the constitutional court and say that, ask the governor why is he holding on to the bill, and try and fix some timelines. If the governor has some justification, so for example, that's why the judgment is also important. For instance, if the governor is wanting to get some research done on a particular subject, before he sends the matter back for reconsideration, and he's getting genuinely looking into the legalities or the social implications of a particular bill, he can justify to the court that, look here, this bill has this lacuna. I'm trying to see if I can suggest something good for that. So if he can justify to the court, probably that time will be given. If he is not able to justify, if he says, no, I'll not sign it because I feel that I don't need to sign it for any period of time, then probably a mandamus will have to be issued. So this power definitely will be available with any constitutional court to direct the governor on a case-to-case basis.
Mr. Vikas Singh, thank you so much for talking to us, putting forward and clarifying the legal nitty-gritties of this very, very important, in fact, observation judgment which has come today.